Hi, this is 512 video number 4. Today's lesson is going to be a scenario that actually happened. You can actually research it. It's called Norm Hall versus the Grand County Board of Ed. And in this particular case, the case was about an employee who was employed as a school psychologist. And over a period of several years, there were performance issues in regard to the school psychologist's effort. So at some point, after several improvement plans, mentors, and some individualized attention, it became apparent that there was not going to be any success in getting the employee to work within the system. Trying to delicately walk around this. So, at the time of a recommendation before the Board of Education to terminate the employee after years and years and different supervisors and mentors working with the employee, a recommendation was going to be made. Days prior to that recommendation being made, the employee showed up with what was called an advocate. And the advocate was there because apparently the employee, the school psychologist, had some disabilities that there had not been any modifications made to meet or to accommodate the needs of the disability of this employee. There had never been any indication upon hiring or any time during the 3 years and all the effort that was made to help this employee that there was a disability. So it became apparent that before I could do a recommendation to the board to terminate an employee, the employee had rights if there was a disability. So we had to step back to try to figure out, well, what do we do now? So what I would like you to do is to think about this scenario. We've talked about students before, but this is an adult under IDEA. So now what I'd like you to do is to think about how you would proceed with this as an administrator and then see if it matches what really happened. So pause at this time, reflect on the scenario, and then we'll see what the outcome is. Okay, welcome back. And in this particular case, I had to cease the termination. There's no way I could terminate someone that had a disability that, first of all, we weren't aware of it, but second of all, we'd made no modifications. The difficulty in this particular situation was that the employee didn't want to tell us what the disability was, but he wanted us to make accommodations. And he wanted to dictate what those accommodations were without us having any feedback or any reflection. Well, what the law says is that it's called reasonable accommodation. And at some point it became obvious that we had to get legal assistance because either it was real or it was being used to prevent a termination because of lack of ability. But either way, legal consultation was done. We brought attorneys in, and Mr. Hall had an attorney. And so what happened was that basically, what is the disability, and we'll make reasonable accommodations. The accommodations he wanted, we would not make. We refused to make. I couldn't. They weren't logical. And it would have prevented me from ever being able to establish whether he could actually perform the task. A school psychologist is a very important position, and you're measuring other students and you're placing them. So we have to know that that person is competent and knows what they're doing. So because of the immediate need of having someone, I did get the Board of Education to actually hire a second school psychologist based on need, and then still hold Mr. Hall accountable for his own actions. It was a long and lengthy process. We did end up in court, and when I retired as superintendent, we at that point were just going up for a recommendation for Mr. Hall to be terminated. However, I'm not sure that that was followed through, and I think it went on for another 3 years. I actually wasn't involved in it at that point, so I don't know how it finally ended. But at the point when I left, he was officially terminated. And so you can terminate someone with a disability, but you certainly have to find out what the disability is, and you have to make those accommodations. In his particular case, I think the disability, it would be in the court documents, I think was ADHD. Well, I myself was diagnosed ADHD, and I didn't require any accommodations. However, he did, and we did make those accommodations. So we gave him a little more time to get reports in. What he wanted to do was basically do 1 report a week, is what I remember. And we were like, no, you've got to do 1 report a day. And you've got to be able to at least see 2 students a day, and you can, we'll work this out, but this is what our expectations are. So sometimes you have to stand strong, and sometimes you have to be willing to fight. Because remember, when you take on these battles, you're not against someone. You're representing the students in your school district. You represent them. You want to do what's right by them. The parents want you to do what's right by them. So you have to divorce all this other circumstance, and you have to say what's the right thing to do. And if the right thing to do is to go to court and to fight, even if you lose, you've still made the effort. So you have to weigh all that out. But in this particular case, I knew I was doing the right thing.